Shall we start off then? I'd like to just focus on one or two areas of the Homelessness Reduction Act that have caused particular problems, or actually, problems isn't quite the right word. In some cases, it may be that, but it just become prominent over the past 6 months. Just by way of introduction, this is the man himself. This is Bob Blackman, the Conservative MP for Harrow East, whose private members' bill it was that became the Homelessness Reduction Act. The bill is based on the Welsh model, because homelessness law in Wales parted company with English homelessness law about 4 years ago, and then there was a crisis review panel that drafted legislation which was taken up by Bob Blackman, became the Act with government support, obviously, because most private members' bills don't make it at all. It came into force, as we know, on 3rd of April, apart from the duty on public bodies to refer, which will be coming into force in 4 days' time, on next week, 1st of October. And that's the subject of Isabel's workshop later on. £61 million funding from MHCLG for extra burdens, and the revised Homelessness Code of Guidance that came out in February. So what do we focus on? Well, I'm going to gloss over the prevention duty just for the purpose of, just for the moment, to focus for a moment on the relief duty. Duty to help to secure accommodation. The word relief isn't actually used in the Act, but, well, actually it's used in a heading, I think. Who's entitled to help? Well, all eligible applicants who are homeless, statutorily homeless, irrespective of priority need or intentional homelessness. Obviously, that's the great thing about the about the relief duty, that priority need and intentional homelessness doesn't come into it at that stage. What do the council have to do? Carry out an assessment, the assessment of circumstances, needs and support, provide a personal housing plan, and take reasonable steps to help the applicant to secure that suitable accommodation becomes available for at least 6 months. So the reasonable steps that then become part of the personal housing plan. How does the relief duty end? Well, this is an appallingly legalistic slide, which I'm not going to go through in detail. You'll be pleased to know. You will, of course, get copies of all these slides, but as Martin said, unfortunately, they haven't arrived yet. Just like to focus on the first one of those, though, the 56 days. Does the duty come to an end automatically after 56 days? Well, not quite. That's kind of how we tend to think of it. But of course, first of all, the authority's got to give notice to bring the duty to an end, except in cases where it has found the person to be in priority need and not intentionally homeless, in which case the person moves seamlessly onto the main housing duty. But in all other cases, the authority has to give notice to bring the duty to an end. And it's not just a case of 56 days, of course, is it? The Act says that the authority must have complied with its duty and 56 days have passed. So it's possible that an applicant could seek a review on the basis that, yes, the 56 days have passed, but I don't accept that the authority have complied with its duty, because I think the authority should have done more to assist me. That might be a possible ground of review. We haven't actually come across any of those situations yet, and slightly surprising, we've been waiting for one to happen, but it will happen undoubtedly in 1 or 2 cases. I'll pass on to how does the relief duty work in relation to the existing duties, or rather the old duties? Well, of course, it runs alongside, in particular, the section 188, the duty to provide interim accommodation, doesn't it? Because the interim accommodation duty, if anything, arises before the relief duty does, because the interim accommodation duty arises when the authority has reason to believe that a person may be homeless and eligible. The relief duty only arises when the authority are satisfied that the person is homeless and eligible. So I should have said the interim accommodation duty when the authority has reason to believe the person is homeless, eligible and in priority need. But apart from that slight mismatch at the beginning, then the relief duty will continue alongside the interim accommodation duty. The two duties will kind of go coterminously until one or other comes to an end, and those are sections in the Act which we won't go there at the moment because they probably are the most complicated sections in the Act, as some of you will know. Okay, if relief activity doesn't resolve homelessness, then applicants in priority need will usually progress to the full homelessness duty after 56 days, unless three main situations where they may not. Obviously, one of them is if the authority finds that they are intentionally homeless, subject to any review. Also, if the authority finds that they've deliberately and unreasonably refused to cooperate with assistance provided to alleviate homelessness, that is, with the steps that they are supposed to take in their personal housing plan. I'll come to that, say a little bit more about that in a moment. Or they've refused a suitable final accommodation offer or a suitable Part 6 offer, an offer from the allocation scheme. That's another situation in which the main duty will be closed off. The review duty will come to an end and it will close off access to the main duty. We can discuss some of the ramifications of that, I'm sure, in our workshops or in the roundup session at the end today. Local connection and the relief duty. This is something that has changed because under the original Act, you could only make a referral on local connection, as you know, if the authority had accepted that the conditions for the main duty applied. Now, of course, you can refer the relief duty. So as an authority, you only have to be satisfied that the first two conditions, homelessness and eligibility, are satisfied, and then you can make the referral if, of course, the person has no local connection with your authority and does have a local connection with another authority and doesn't run the risk of violence in the other authority's area. So how does that work? Second bullet point there, once the authority notify the applicant that they intend to make a referral, have made or intend to make a referral, they cease to be subject to the relief duty. So the relief duty then goes into limbo. Nobody owes it for hopefully a short period of time. But the original authority, Authority 1, should we call it, must continue providing interim accommodation to an applicant in priority need, pending a decision on whether the local connection conditions have been met and whether the referral has been accepted by Authority 2. And moving on from that, when it's been decided between the two authorities whether the local connection conditions are met, Authority 1 then gives notice of that decision to the applicant, and if the conditions are not met, the duty bounces back to Authority 1, and obviously Authority 1 must then provide the relief duty and continue providing the interim accommodation. If the conditions are met, the applicant is treated as having made a homeless application to Authority 2. And all the duties then transfer to Authority 2. Authority 1 owes no duty from then onwards. So that's how the system works, if it works as it should. Couple more issues just to put before you. Deliberate and unreasonable refusal to cooperate. The notion of unreasonable to cooperate came from the Welsh model, but in Wales it's simply a failure to cooperate. This is a much stronger phrasing. Deliberate and unreasonable refusal to cooperate. Much kind of stronger level of non-engagement. Strong isn't the word. Much lower level, should we say, of non-engagement than failure to cooperate. And so an authority can bring the prevention or the relief duty to an end on the basis that the applicant has deliberately and unreasonably refused to take any step that they've agreed to take in the personal housing plan, or that the authority has said that they should take if they didn't agree to it. The process is that the authority must first give a warning notice, two notices. First, a warning notice warning the applicant that they are at risk of having the duty brought to an end if they don't engage, and that must give a reasonable length of time. We would probably at least 14 days. And if there is still no improvement in the engagement, shall we say, then the authority can serve a final notice on the applicant, bringing the duty to an end, giving him or her a right to request a review, and the time limit, 21 days, within which to request the review. And what's the consequences of that, where that final notice is served? Well, it brings the authority's prevention and relief, well, prevention or relief duty, whichever it is, to an end. If the prevention duty comes to an end, doesn't stop the applicant going on to the relief duty eventually if they become homeless. If it brings the relief duty to an end, then it will close off access to the main housing duty, except that there is a kind of consolation prize for the applicant, in the sense that the authority must still make a final accommodation offer to the applicant, short-hold tenancy, at least 6 months. So in many ways, the person still gets an offer of what they might have got anyway under the main housing duty. Of course, if they've not engaged so far, they may not engage with that either. But that's the offer that needs to be made to satisfy the final duty in relation to somebody who hasn't cooperated. The code of guidance is helpful, that providing that authorities must have regard to the particular circumstances and needs of the applicant, whether or not they're identified in the personal housing plan, in deciding whether the refusal is unreasonable. So are there mental health difficulties, or are there other pressures or circumstances that may be causing or maybe having an effect on the applicant and may lie behind the refusal to engage. Okay. Just coming towards the end of the HRA, the Homelessness Reduction Act section, but we just ought to remind ourselves that there are additional rights of review under the Act because of the new duties. So there's a right of review of the decision in the first place, whether the local authority is subject to a prevention duty or a relief duty. There's a right of review of the steps themselves, but only the steps that the authority has agreed to take. There's no right of review as such of the steps that the applicant has agreed to take, although that may be relevant to the next right of review of a decision to bring either duty to an end. So if an applicant requests a review of a decision to bring the duty to an end, the applicant may be saying as part of that some of the steps that you imposed on me I consider to be unreasonable. So that the nature of the steps may come into it when in relation to a decision to bring the duty to an end. Then find a right of review of the suitability of a final accommodation offer is also available. What about the time limit for conducting reviews? I'm afraid this is a very wordy slide, but what it amounts to is that the time limit for carrying out a review is generally 8 weeks, another 8 weeks, another 56 days, just as it used to be, except that some of the new rights of review would be kind of academic if you allowed 8 weeks, particularly the prevention duty, because things would have moved on during that 8 weeks. So there's a shorter period of 3 weeks for certain decisions. First of all, the reasonable steps themselves, which authorities are to take under the prevention or relief duty, so the reasonable steps in the personal housing plan, a decision to bring the prevention duty to an end, not the relief duty, that still has a full 56 days, a full 8 weeks, just the prevention duty, and a decision to give the applicant notice that they've deliberately and unreasonably refused to cooperate, where that brings the prevention duty to an end, just the prevention duty. So I think that makes sense in terms of the shorter period. Okay, I'm not going to go through the next 3 slides because I'd be trespassing on Isabel's session on the duty to refer, but the slides will be in the pack that you'll get. Okay, so I'll move on. I'm sorry that I'm taking it at something of a pace, but we'll hopefully have time maybe for a few questions at the end. This is, oh sorry, I'm not quite finished, have I? There are some HRA issues that I just want to round up with. First of all, the end of the relief duty. We've kind of anticipated that when we had that wordy slide before about how does the authority bring the duty to an end. And will an applicant in priority need move on to the main housing duty automatically after 56 days? Well, only, of course, if they've been found not intentionally homeless, is broadly the answer to that. We might also have the next issue is, can a person ever become intentionally homeless under the relief duty? The Act says that you can be intentionally homeless because that's one of the list of circumstances that can bring the relief duty to an end. But when you actually look at it, and the Code of Guidance said this will happen very rarely, because if you've been provided with accommodation that lasts for 6 months, then normally the authority will have brought the relief duty to an end on that basis. You'd have to have lost that accommodation very early, very quickly, to be considered intentionally homeless from it. Maybe we could discuss one or two of those issues arising from that, because I know this causes quite a few problems that have arisen on our consultancy line. Discuss that perhaps a little later. Local connection. What's the situation where the receiving local authority, that's authority 2 in our example, has previously made a negative decision concerning the same applicant? So the applicant has had a decision of perhaps non-eligibility or intentional homelessness with one authority, then goes to another authority, applies there, and is referred back to that authority, the original authority, on the relief duty. I'm going to leave that hanging because that needs a bit more discussion than we've got time for, but we will return to that later on. The only other issue I'd mention just here is basically about refusal to cooperate. You know, what level of non-engagement does that involve? How low or high a level does that involve before an authority is justified in considering it to merit the termination of the duty? Again, I mean, that's an interesting issue which I'm sure we'll get to later on. Okay, shall we move on then to a selection of homelessness cases over the past 12 months. And there are about 7 or 8, but I'll go through them with hopefully a very light touch. So, and again, I'm afraid the slides are very wordy, so don't worry about the detail of them. Lomax and Gosport, this is a recent case a few weeks ago. Miss Lomax, severely disabled and wheelchair bound. She was unable to live independently, needed 24-hour care, and her physical and mental health was deteriorating because basically she needed to live in Gosport because that was where her family network are, who could provide her with support. But she lived in a property that was adapted for her needs. It was physically suitable, but it was in rural Dorset, 70 miles away. So she applied as homeless to Gosport on the basis that it wasn't reasonable for her to continue to occupy the accommodation that she's currently in. The council said no because they said we're entitled to take into account housing circumstances in our area, and we have many other people on our housing register who are already living in accommodation that is not ideal for them, as the reviewing officer put it. She appealed against that decision. She didn't succeed in the county court, but she did succeed in the Court of Appeal. And the Court of Appeal said this is all about the public sector equality duty. She's obviously a disabled person, which is a protected characteristic under the public sector equality duty. And that demands that the authority applies what's called a sharp focus to her particular needs, to the nature of her disability, the effect of it, and what would be needed to remedy her predicament. And the the Court of Appeal said they didn't feel that Gosport had applied how can I put it, had given that adequate attention in the way they had made their decision. And the reviewing officer had failed to account for the fact that Miss Lomax's location was causing her health to deteriorate. Now, that doesn't mean necessarily that Gosport had to change their decision, because, of course, the Court of Appeal the courts don't change decisions generally. They generally refer them back to the authority to approach the decision again in a different way. But there's a fairly strong steer, I think, from the Court of Appeal there that they would expect Gosport to find it unreasonable for her to continue to occupy. So that's Miss Lomax. Mr. Sambertin against Brent. This was one of our cases. This was a case in London, and it's a familiar situation of a battle between two London authorities. And this is a case where Mr. Sambertin, very sad situation. He was a perfectly fit gentleman who came from Romania and worked here for some years, went back to Romania for a holiday, involved in a serious car accident and ended up a wheelchair user. And he was living in Waltham Forest. He came back to the UK, applied as homeless to Waltham Forest, who decided that although he had been working here, decided that he didn't have a right of residence, and so he wasn't eligible for assistance. We won't go into the detail of that, though there were issues either way on that. So he then got accommodation in Brent, which is over the other side of North London, and they accepted a duty towards him. They considered that he was eligible for assistance, but because he didn't have a local connection with Brent, they referred him back to Waltham Forest. And Waltham Forest said, but we've already made a decision on Mr. Sambertin's case. We're not having him back, thank you very much. And so Mr. Sambertin's being passed, a bit like pass the parcel, back and forth. So he goes back to Brent and said, well, you've accepted a duty towards me. Will you house me? And Brent said, well, no, we won't actually, because we're now withdrawing the referral to Waltham Forest, and we're going to change our decision. We're going to decide that you're not eligible after all, even though they'd found that. And so that was the issue that went to court. Can an authority, having made its decision once, can it change its decision and make a negative decision in effect? And the Court of Appeal said no, it couldn't. Where it had already completed its inquiries and accepted a full housing duty, it couldn't then simply revise its decision because it felt it had got it wrong, even if the original decision had been somewhat generous, and now, of course, Brent is aware that Waltham Forest hadn't been so generous. Once the decision is made, as a matter of public law, it can't be changed unless there's some fraud or deception on the applicant's part or a fundamental mistake of fact. Brent tried to say that there was a fundamental mistake of fact here, but there wasn't, in fact. It was just that they wanted to revise their decision. I mean, I think that's a right decision on principle, even though the circumstances are somewhat strange. I think that situation of people going from one authority to another is going to happen quite a lot now that there is the ability to refer the relief duty on local connection. And so, again, that's the issue that I raised under the HRA issues about where one person has been turned down by an authority and then applies to another authority and is referred back again. And again, we'll perhaps look at the implications of that a bit later on. Okay. Probably the main case of the last year, even though it's showing its age now, so it was about in October last year, is the decision on vulnerability. Paniotto and Waltham Forest, and another case, Smith and Haringey. As you may recall, the question of vulnerability went to the Supreme Court about 3 years ago in a case called Hotak. And the Supreme Court said that to consider a person vulnerable, or in assessing whether a person is vulnerable for the purposes of priority need, an authority has to ask itself, is the person significantly more vulnerable than the average person, the ordinary person would be, who is facing homelessness? not more vulnerable than the average person who is already homeless, which is what one of the authorities in the cases had been deciding, because that's far too high a bar. The comparison is with somebody, with any of us. Now, I mean, how would any of us fare if we were facing homelessness? But it's basically on the basis that, that the comparison is with the ordinary, averagely robust person. It's a fairly artificial exercise, as we know, but that's what it is. But it left one or two loose ends hanging, even despite the fact that this was the first time that vulnerability had ever been considered by the Supreme Court. It resolved some issues and left others open. And one of them was what is meant by significantly more vulnerable. How high is that on the level of vulnerability? And this was the situation that came before the Court of Appeal here. We're not told very much about the two young men who were the subject of these decisions. Mr. Paniottou suffered from anxiety and depression, lived in constant fear of reprisals from gangs, and sadly from his own father. We're not told what the circumstances of that were. Mr. Smith suffered from mental health problems and chronic leg pain. Both applied as homeless, both were found not vulnerable, and this was their appeal to the Court of Appeal. And the Court of Appeal had to grapple with the meaning of what significantly more vulnerable meant, what it was. And you can sense a sense of exasperation in the Court of Appeal, saying, why have we been left this hot potato by the Supreme Court? Why couldn't the Supreme Court have resolved all these issues? Because the judge said it's easier to say what the law is not rather than what it is, which is very comforting for all of us, I'm sure. But they said that the authorities' focus will be on whether there is an impairment of a person's ability to find accommodation, or if she or he cannot find it, to deal with the lack of it, which is not a bad formulation. And then they went on to say that the impairment may be an expectation that the person's mental or physical health would deteriorate, or it may be exposure to some external risk, such as exploitation by others. But they still haven't confronted what significantly more vulnerable means. So they go on to say that the word significantly did not denote a quantitative threshold. It doesn't mean more harm plus. The word is used in a qualitative sense. Now, what on earth does that mean? Which is what was our reaction when we first read it. I think what it means is that significantly more vulnerable doesn't mean that you have to measure someone on a scale of vulnerability between low-level and high-level vulnerability on a kind of spectrum and place the person sort of somewhere in the middle or high up, which is basically, I think, how authorities had been assuming, and we had been assuming that as well, that there was a kind of bar and you still had to reach it. But what the Court of Appeal is saying basically is that significantly just means vulnerable in a significant way. And I know this is kind of playing with words, or it sounds like playing with words, but essentially I think what this means is that the word significantly doesn't actually mean very much at all. Because what they offered a new formulation, which is this, that is the applicant at risk of suffering harm or detriment which the ordinary person would not suffer and which would make a noticeable difference, another word, noticeable difference to his ability to deal with the consequences of homelessness. Well, that's not a bad formulation. And I think I mean, the Court of Appeal was anxious to say this is not the new test. This is just another way of formulating it. But I think you wouldn't go far wrong if you took that as your kind of guide in making a decision or a review decision. The court still had to make a decision in the cases themselves. And so we have to ask ourselves, which was the lawful review decision? And this is a bit unfair to the reviewing officers, because the reviewing officers here wrote decision letters of 13 or 14 pages, because priority need decisions tend to be fairly long. But it all comes down to one sentence at the end. And in Mr. Paniotou's case, Waltham Forest, the reviewing officer, had said, I am not satisfied that as a result of your condition, you would be at more risk of harm from being without accommodation than an ordinary person would be. Okay? And then the reviewing officer in Mr. Smith's case said, it may very well be the case that you are more vulnerable than ordinarily vulnerable, but I am not satisfied that you are significantly more vulnerable or even more vulnerable than ordinarily vulnerable. And so I think you can sense which of those the Court of Appeal went for. It was the first one. The first one was the right, it was a good way of phrasing. It's a summary, obviously, of a whole thinking process, but of phrasing the outcome. The second formulation was the quantitative way of expressing it, which the Court of Appeal disapproved of. And what the Court of Appeal said, well, you started off saying it may very well be the case that you are more vulnerable than ordinarily vulnerable, and he should have stopped there instead of digging a hole for himself with the rest of the verbiage. So that's kind of it's all deconstructing language, isn't it? It's all a little bit artificial, but still, it's of some help, I think. So just two more slides on vulnerability. There was another case, Rother District Council against Freeman Roach. This was a case where Mr. Freeman Roach had suffered 2 strokes, the second one in 2013, suffered from expressive aphasia, difficulty in formulating his words, osteoarthritis in his hands and knees, asthma, high blood pressure. None of these things would have been enough in themselves to make him vulnerable, but as a composite, then arguably they may have been. Council said that they didn't consider that Mr. Freeman Roach was significantly more vulnerable, because that was the test when they made the decision, than the ordinary person if made homeless. His conditions were controlled by medication or didn't cause functional impairment. Functional impairment is a slightly strange notion that's crept in, I think, as a result of Now Medical, which is the medical agency that many authorities use. I'm sure it will be familiar to some of you. There's, I think, an issue about whether functional impairment should be part of the test, but we'll park that for the moment. The County Court allowed Mr. Freeman Roach's appeal. He was successful in the County Court, but then Rother appealed, and the Court of Appeal upheld their appeal and said, no, the reviewing officer had got it right. He or she had considered Mr. Freeman Roach's circumstances in the round. And one of the judges said, it's not for the reviewing officer to demonstrate positively that he has correctly understood the law, which will be a comfort. The reviewing officer is not writing an examination paper in housing law. So we're expecting that will figure in a lot of local authorities' decision letters from now on. It's basically, the courts have taken the view, obviously, that lawyers such as ourselves have a habit of deconstructing every word in a reviewing officer's letter, and the courts say, no, you mustn't do that. It's not a statute, it's not a piece of legislation. You'll have to look at it with a broad brush. It's fair enough. Okay. Is that the end of vulnerability? I mean, don't mean the end of vulnerability, but that the end of any problems concerning vulnerability, or are there any further issues that are likely to trouble the courts? There are 1 or 2 issues that are kind of still going on, which may yet reach the Court of Appeal. One of them is when the Court of Appeal in the Paniotu case said that the question was whether the applicant would suffer harm whether it would make a noticeable difference to his ability to deal with the consequences of homelessness. Is this the new formula? That's one question that's been raised. And I don't think the courts are going to have much patience, actually, with yet more cases dissecting the words that are used. I think the Court of Appeal is going to take the view that we have to get on with it now, both authorities and applicants' representatives, that we're going to have to make the best of what the courts have tried to do, and in their slightly inadequate way maybe, but you have to make the best of it. What are the characteristics of the ordinary person? That's apparently one case that may or may not be on the way to the Court of Appeal. Because there was a County Court appeal not so long ago on the basis that if an authority is making a comparison with the ordinary person, it ought to have some idea of what the characteristics of the ordinary person are. How robust must the ordinary person be? I don't think really that's going to get anywhere either, because the ordinary person, again, it's an artificial concept, isn't it? I was at a meeting of housing lawyers not so long ago when somebody in the audience stood up and said with great confidence that she felt that the ordinary person was aged 38 and female. And I don't know where she got that from. I think she was slightly tongue-in-cheek, but she was saying that was a possible construct, or age 38 and male. But it's true. But I mean, there is an issue here. I mean, how do you compare a person in their 20s, somebody in their 40s, somebody in their 60s? These are difficult issues, aren't they? Okay. Finally, is the applicant to be assessed on the basis that he and the ordinary person are street homeless? Do you imagine these two people, the actual person and the imaginary person, on the street in order to make the comparison? Again, I don't think the courts are going to have much patience with that either. I think, you know, we're talking about people who are living in very insecure accommodation, maybe sofa surfing, maybe just simply not knowing where they're going to be from one week to the next. And I think it's that kind of that insecurity of accommodation that's the test that's being applied, not necessarily actually being on the streets or sleeping in a car or something like that. Okay, shall we move on from vulnerability to a case involving intentional homelessness? And this is a case about once a person has been found intentionally homeless, how do they rid themselves of that stigma of intentionality? If they want to make another homelessness application in the future, can they do so? Well, the courts have said, well, they've got to find some settled accommodation before they do so to break the chain of causation between that original finding of intentional homelessness and their present situation. And this was a case about that. This was Mr. Doka, who'd been evicted for rent arrears and found intentionally homeless. And he had a kindly former employer who said, why don't you come and live in my son's room while he's away at university? You'll have to move out occasionally if my son wants to come back for the weekend. And if he wants to come back in 2 years' time when he's finished, then I'm afraid you'll have to move out for good if he wants to come home. And that's what happened. So Mr. Doka stayed away on occasional nights when the son came back, and after 2 years, the son came home for good, and Mr. Doka had to leave. And the question was, he then applied to Southwark, and Southwark had to ask themselves, was this settled accommodation that broke the chain of causation from his original intentional homelessness? Court of Appeal said, no, it wasn't. And the reason for that was they said that accommodation isn't settled unless it has a real prospect of continuation for a significant or indefinite period of time. Well, you'd think, well, this is a significant period of time, isn't it? This is 2 years. Does it have to be indefinite? That's a really high test, isn't it? How many people could satisfy that test? Because the best you can do these days is an assured short-hold tenancy, 6 months, 12 months if you're lucky. We'd tend to argue that as long as that was suitable and affordable, that would break the chain of causation. Mr. Doka's been in accommodation for 2 years. But the court said the arrangement here was always precarious and finite. It was always going to come to an end. And I suppose, again, the assured short-hold tenancy wouldn't necessarily break the chain of causation if the person knew that it would only be for 6 months or only be for 12 months, and then it would come to an end. And priority was given to the son's need for the room. So, not sure. I mean, the decision could have gone the other way, couldn't it? You might have thought that was slightly harsh on Southwark's part, but maybe not, maybe not. Okay. Coming towards the end of our case law now, just mention the Hillingdon allocation cases. This is about the London Borough of Hillingdon and its 10-year residency condition. As we know, the Allocations Code of Guidance encourages local authorities to apply a residency condition to people to join the housing register or to give additional priority to people who have residence in the borough for a particular length of time. Hillingdon take it to extremes and place a 10-year residence condition. I don't suppose any authorities in the southwest have 10 years. Maybe they do. You can tell us later. So, really, that's interesting. Thank you. But 5 years is fairly common. 2 years is very common, I think. But this was a challenge to Hillingdon's policy that only households with 10 years continuous residence would qualify for the priority bands, the welfare bands A to C, and there was also additional priority given to people with those 10 years residence in bands B and C, so that those two really go together. And the additional preference was also given to working households on a low income in bands B and C. Other homeless households were placed in band D and effectively were not going to be made an offer for many, many years, if ever. And there was an equalities impact report that Hillingdon had prepared which noted that the 10-year residence condition would have a negative impact on mainly BME, black and minority ethnic residents. So the question was, did that essentially, had Hillingdon had regard to its duty towards those with protected characteristics under the Equality Act? Is there a discrimination issue here? And there were two challenges. The first challenge was on behalf of traveller families. TW, SW, EM, they were all the applicants in these two cases were of Irish traveller descent, living in temporary accommodation. TW was a lone parent caring for her child. EM was disabled, a disabled father, and was also caring for 3 disabled adult children. So there was no prospect of him working in terms of the working households uplift. So how did they fare in their challenge? Because of course the argument was that both the 10-year residence qualification and the working households uplift discriminated against Miss TW on the basis of gender, because she was a single parent caring for a child, and EM because of his particular caring responsibilities and his own disability. And the residency condition discriminated against them both because of their status as travellers, their nomadic lifestyle. And that was the argument that succeeded. The High Court said that both the 10-year qualification and the residence uplift amounted to indirect discrimination against travellers on the basis of the protected characteristic of race. Travellers fall within the characteristic of race, and also in breach of the duty under the Children Act 2004 to promote and safeguard the welfare of children. But the working households uplift was lawful. That wasn't discriminatory. It was limited in scope to people who were working and on a low income, and it was proportionate. And so it was discriminatory, but that's not enough, because an authority can argue that even though it is discriminatory, it serves a legitimate purpose and it's proportionate to that aim. And so Hillingdon succeeded on that limb. So it was just the residency argument that succeeded. But then we compare this case with the other case, decided only a couple of weeks later by a different judge. And this was Mr. YG, who was a refugee. And he also challenged the 10-year residence condition. The working households condition didn't feature in this case. On the basis that refugees as a class would find it more difficult to satisfy the rule. Because refugees don't, by and large, have any choice as to the borough they land in. Often it's because they were placed there on asylum support, by asylum support. And of course, they haven't chosen to come to a particular borough in any event. But the High Court said in this case the residency condition was lawful. Any difference in treatment was on the basis of short-term residence, not because he was a refugee. He wasn't in the same position as a traveller, because of course the judge was conscious of the fact that the earlier decision had already taken place. And they said, well, the judge said, travellers are different because a traveller was less likely to complete the 10-year journey, the way he phrased it. Whereas a refugee was no different to a voluntary migrant from this purpose. When it comes to starting the clock and counting the days, their situations are the same. Well, I'm not sure. I'm not sure those two cases sit very well together. Difficult to pin it down, I think, but I'm sure there will be appeals by both parties, in the losing parties in these cases, and the Court of Appeal is going to decide. So this time next year, we'll probably have a decision that goes one way or the other in both cases. But at the moment, that's how it stands. Hillingdon would obviously have to revise their residency condition as far as traveller families are concerned. Otherwise, it's been upheld, and the working households condition has also been upheld. Okay, well, we're coming towards the end now. I'd just like to spend 10 minutes or so on the private rented sector. And again, this is very timely because in 4 days' time, there are various changes that come in, which are, they may not affect a lot of tenancies, but they will affect a few. Because some of you will remember that the Deregulation Act 2015, when it came in October 2015, it put various restrictions on Section 21 notices, the notices that landlords serve on assured short-hold tenants to bring their tenancies to an end, or as a preliminary to bring their tenancies to an end. And as we know, Section 21 notices are the largest cause of homelessness applications. So this is quite a significant, so there are obvious links here with prevention of homelessness. And when these changes came in, and I'll say a bit just in a second what those changes were, the Act said that they only applied to tenancies that began after the 1st of October 2015. But in 3 years' time, on the 1st of October 2018, they'd apply to all tenancies, even those tenancies that started before October 2015. So it's like a 3-year moratorium for landlords to get used to the changes. And I remember sort of saying 2015, oh, well, that's in 3 years' time, that's a long time. And here we are, 4 days' time, how quickly our lives go by. Okay, what are those changes? Well, first of all, 2 calendar months' notice. There used to be a rule that with some tenancies, some periodic tenancies, monthly tenancies, that the 2 months notice had to end on the last day of a period of the tenancy. Now that's gone, and it's gone for all tenancies. So it's just 2 calendar months. So if you serve notice today, the 27th of September, it can expire on the 27th of November. Okay, don't have to take it up to the last day of the month or anything like that. Notices have a shelf life of 6 months from the date of service. So it's use it or lose it. So the landlord serves the 2 months notice, that 2 months goes by, he or she then has 4 months left to start court proceedings, assuming that the person doesn't move out. Obviously, the landlord's intention is that the tenant will move out after 2 months, but if they don't, the landlord has to start proceedings, which usually be the accelerated possession proceedings, within 4 months. In other words, 6 months from the date the notice was served. There's another rule it's not on the slide, which is that landlords cannot serve Section 21 notices within the first 4 months of an initial tenancy. First 4 months of an original tenancy, the landlord can only serve their notice after 4 months have gone by. So in other words, the tenant gets at least 6 months, a guarantee of at least 6 months. Unfortunately, if the tenancy is renewed, that rule doesn't apply. So the tenancy is renewed, the landlord can serve the notice as soon as they like in the renewal tenancy, which has always seemed to me to be strange. Why not apply the 4-month rule there as well? Anyway, that's how it is. If there's an improvement notice, if environmental health have served an improvement notice, the landlord can't serve a Section 21 notice in like retaliation for 6 months after the improvement notice. And very importantly, Form 6A. The notice now has to be in a prescribed form, doesn't it, which is the Form 6A. Easily downloadable, free to download. Some landlords still, for some reason, best known to themselves, want to type out their own notice and just happen to miss out some of the bullet points that are addressed to the tenant in doing so. It must be in Form 6A. It's a little bit uncertain whether that still applies. Very unsatisfactory, the way the regulations are drawn. But any landlord would be very unwise not to use Form 6A for all tenancies, even the older tenancies, after 1st of October next. What doesn't apply to the older tenancies? Well, the requirements for the gas safety certificate and the energy performance certificate. For tenancies that began after 1st October 2015, the landlord has to have given the tenant gas safety certificate, energy performance certificate before the Section 21 notice will be valid. That still doesn't apply to the older tenancies, but obviously as time goes on it will increasingly apply to all tenancies because all tenancies will be newer tenancies. The duty to give a copy of the How to Rent booklet. You know, that's the checklist for renting in England. It's a 40-page booklet addressed to tenants. It's quite a good resume of the law of landlord and tenant. That only applies to the newer tenancies since 1st of October 2015. So if we're embarking on a prevention exercise and looking to prevent homelessness and somebody comes into us with their Section 21 notice, then what we will ask them first of all is, you know, when did your tenancy start? If the answer is after 1st of October 2015, as it will be in most cases, then all these rules, including the gas safety certificate and energy performance certificate, all those new rules apply. If the tenant says, oh, well, my tenancy started back in 2014 and it hasn't been renewed since then we just have to look at that list and say, well, you know, some of the changes will apply, not all of them. And the main ones that don't are the gas safety and the energy performance certificate. Okay, just to draw your attention very briefly, some changes in the law which are basically of a kind of consumer nature. And there's increasingly a tie-up between housing law and consumer law. And that involves the use of the first-tier tribunal rather than the ordinary courts. And this is one of those. This is a rent repayment order. And it's part of the Housing and Planning Act 2016 under the heading Rogue Landlords and Property Agents. First time I think the term rogue landlord has ever been used in an Act of Parliament. And that's where a landlord has committed a housing offence, such as harassment, illegal eviction, letting premises unlicensed, using violence to enter a property. If any of those things have happened, even if though there's been no conviction, doesn't have to be an actual criminal conviction, the tenant or the local authority can apply to the tribunal for a rent repayment order for up to 12 months worth of rent or the housing element of universal credit, if it's the authority, to be repaid by the landlord. And that can amount to quite a substantial amount, as you can imagine. It's a rather more accessible way for a tenant to get some compensation than going to the county court. They still could go to the county court for something like harassment, certainly for illegal eviction, and they'd probably get more more in the way of damages, compensation through the county court. But this is perhaps a more accessible way of seeking a remedy. Another change is banning orders, which have been in force since April this year. This is obviously the more serious situations. Well, of course, they're all serious. Any breach of housing law is serious. But this is where there's been an actual conviction in the magistrates' court for not only a housing offence, but for a range of offences. I'll mention that in a moment. And here, a housing authority can apply to the tribunal for a banning order prohibiting a person from letting or from letting property or working as a letting agent. So in other words, it applies both to landlords or agents or as a property manager. Only applies if the person has been convicted, and the Secretary of State has established a database. Local authorities have to enter the names of landlords against whom they've obtained a banning order in the national database, which is available to local authorities to inspect. It's not publicly available as yet. There are 41 different offences which can be the subject of banning order applications, not just housing offences, but all sorts of offences involving violence, theft, drug-related offences, even dangerous driving can come into that scope. Banning order lasts for a fixed period of at least 12 months, during which the landlord will have to try and show that they've put their house in order, and likewise the agent. If not, presume they'll have little alternative but to sell the property to someone who will manage it properly. And breach of a banning order is a criminal offence and can attract a fixed penalty of up to £30,000 by the local authority. And worth local authorities enforcing this, because they get to keep the money if the penalty is imposed, which is always worth thinking about. Okay, we'll end with a couple of bills, forthcoming attractions that are going through, and just with a couple of pictures. The Fitness for Human Habitation Bill is a private member's bill introduced by the excellent MP Karen Buck, Westminster MP, it's got government support in the same way as the Homelessness Reduction Act does. And what this does is that it introduces, or it reintroduces, a landlord's obligation to keep property fit for habitation at the start of and throughout a tenancy. Now, you would think, well, surely isn't that the law at the moment? Mustn't a landlord keep properties fit? And the general public might be astounded to find that no, it isn't. I mean, there's a liability for disrepair, isn't there, for landlords, but that doesn't cover things like condensation dampness or infestation, unless it's caused by structural disrepair. This is a much broader concept of fitness for habitation, and there'll be 9 fitness standards plus some prescribed hazards under the Housing Health and Safety Rating System that the Environmental Health operate. And this is a much wider obligation than the disrepair duty is. And in many ways, disrepair may almost become irrelevant if this, that's probably taking it too broadly, but this may become the main liability or the main remedy for tenants once it's introduced. Now, it's not guaranteed to get through. Private members' bills will fall if there is a change of government or if the government collapses, and who knows what's going to happen over the next few months. But if it does get through, it's likely to come in next April. And it will apply to all new tenancies, and after that date, and 12 months on, it will apply to all tenancies. Not 3 years, 12 months. That's a really good development, I think. And the other really good development is the Tenants' Fees Bill, which is a government bill, so credit to communities and local government. And we're all aware of the fees that some landlords and letting agents charge for creating a tenancy, renewing a tenancy, inventory fees, exit fees, fees for professional cleaning, all those things that are hidden away in the 19 or 20 pages of a tenancy agreement. Especially affects student accommodation, but it also affects other accommodation as well. And the way the bill operates is to ban all those fees, and the way it does it is to say that all payments are prohibited unless they're specifically allowed. And the payments that are specifically allowed are rent, tenancy deposits, holding deposits at the start to secure a property, utility bills, obviously. The one weakness in the bill is payments in the event of a default. So that's basically where the tenancy agreement levies a fee or like a fine on tenants if they breach the terms of their tenancy. So what about those clauses that you may have come across where the landlord says, well, if you fall into arrears with your rent, that's £25 every month you're in arrears, or £35 for every time I send you a letter, or my agent sends you a letter complaining that you're in arrears or about some other aspect that you've lost your key or something like that. Those default fees are allowed provided that they represent the landlord's reasonable loss, actual or reasonable loss. That's a little bit vague, and we're unhappy about the inclusion of default fees because, as far as we can see, that's a real loophole in the bill which agents will exploit. And they've already indicated that they will exploit them. They'll try and load all their fees onto these relatively minor. Well, I don't say that rent arrears are minor, but just falling into a rent arrears for a week or so, they'll charge higher fees. But as I say, at least it does have to represent the landlord's reasonable loss. Okay, our last two slides are pictures. These are both about the conjunction of housing and consumer law, because there are two authorities that are in the vanguard of using consumer law to raise standards. And this is a report from the Islington Gazette. Holloway Road letting agent, first in UK to be convicted of issuing sham licences. Now, sham licences, which you may have come across, are they're agreements, printed agreements, which some landlords and agents give to people who are expecting to are renting a property. They think they've got a tenancy. Their agreement says, no, you haven't got a tenancy. You've only got a licence. You haven't got exclusive possession of your property, and therefore we don't have to protect your deposit. We don't owe you any repairing obligations. We can drop in on your property whenever we want, uninvited, because that's what a license is. It's like a lodger situation, isn't it, or a hotel or a hostel situation where you don't have exclusive possession of any part of the property. And these agreements are used to try and disguise a tenancy. And up till now, we'd always thought that those only had civil consequences, that they would that a person could defend a claim for possession on the basis that we're not a licensee, we're actually a tenant. But Islington trading standards take the view that this is misleading information under the Consumer Protection from Trading, one of the trading standards regulations, forgive me, I've forgotten the exact title, that this is misleading information, and as such, it's a criminal offence. And so they prosecuted the agency for issuing these licences, and the agency was fined £5,500 on each of two agreements, and the two tenants, the two occupiers involved, got £3,000 each in damages for the insecurity that they had felt, the lack of protection of deposits, all those consequences that the landlord had derived from that situation. So that's a really imaginative, I think, use of consumer law. Depends on trading standards, obviously, because trading standards are the enforcers in this situation. And finally, the other council is Nottingham City Council. And this was a situation where, again, this is from Environmental Health News in July, rogue landlord told to pay £30,000 or go to jail. Nottingham landlord prosecuted for breaches of housing and consumer law. He let his house to, to 6 students. He'd let himself into the property whenever he pleased and threaten and intimidate them. For reasons best known to himself, he'd drive in at night and park in the driveway at 11 o'clock at night and just stay there. Safety issues and poor management. 2 of the students moved out early and a third dropped out of her course. There may have been other reasons for that, but no doubt the accommodation situation had something to do with it. The landlord was fined £3,300 on HMO offences, and each of the students were awarded the return of a year's rent in compensation. It's a good return. The council itself recovered £12,000 in costs. So again, it can be cost neutral, as long as they can enforce it against the landlord, and of course they can, because there's a property to enforce against. The landlord was sentenced to a suspended prison sentence of 4 months, 150 hours community service. His HMO licence was revoked, and he was also a minicab driver, and his minicab licence was revoked as well because he was not considered a fit and proper person, either to operate an HMO or to run a minicab. So there we are, an imaginative use of housing and consumer law. And that's it. Thank you for your patience, and we'll return to those outstanding issues about the Homelessness Reduction Act later in the day. I'll hand back to Martin now.